Yes, counsel, proceed.
Good morning. May it please the court. Jeffrey Baylor for Michael Bizanowicz. Here, first off, we contend that a constitutional error arose when one chemist testified at trial to the results of tests performed by another chemist.
Why was there no objection? I mean, this is a classic hearsay situation.
Right. And that's one of the big issues in this case. At the time, Crawford, it was past Crawford, but Verdi was controlling.
Yeah, but Verdi involved a drug certificate, which statutes clearly permitted to be admitted into evidence. This is not a drug certificate.
Right, but we contend that Verdi, to a larger point, went to the business record exception. And I think Nardi makes this clear. And Nardi dealt with one medical examiner giving testimony of another medical examiner.
Yeah, and the court held that the testimony, in part, in fact, was inappropriate. The sort of factual findings that were related by the testifying medical examiner that were actually the findings of the actual medical examiner were problematic. Exactly,
except this court said that test results, specifically saying toxicology test results,
is this a toxicology test? This is an investigative trying to see if there's any evidence of fluids.
It's another scientific test.
Well, it's an investigative technique. It would be like I'm looking to see if they're hairs, or if I'm looking to see if there's something else.
True. Well, that was one part of it. There was a test under an alternative light source, but there was also a scientific phosphatase test done for the presence of semen.
Well, let me ask you this. I mean, one of the problems here faced, it seemed to me, by trial counsel is that this testimony, the testimony of this person who did this examination, if you called the person, well, the person would probably testify pretty strongly, and there wouldn't be much to cross-examine the person about. And a lot of the evidence collected, or at least a lot of the testimony, was favorable. There was no semen here, there was none there, there was no, I mean, it was actually favorable and consistent with the defense. But there's one part that wasn't. And why isn't it reasonable for a trial counsel to say, yeah, I can force the Commonwealth to call this witness? Because there have been lots of discussions about whether the folks that gathered the evidence would be called, and defense counsel said, I don't have any intention of making you call those people, or at least that's how I understand the record. Why doesn't it make sense from a strategic point of view to do exactly what counsel did here, to try to get the evidence in a favorable way and then also be able to criticize that evidence that was most incriminating because the person who did the testing wasn't there? And we don't know if he did it just right.
Well, I mean, first of all, I think Melendez-Diaz makes it clear that there's no substitute for a cross-examination.
But you can make choices about this, and lawyers make choices about this all the time. You frequently don't want experts called if you're a defense lawyer because the experts are going to be devastating.
Well,
you'd rather not have them called.
If that held true, then in all these drug certificate cases that are being reversed, the same argument could be made because likely those drugs would be tested and they would come back the way that the certificate said. But the U.S. Supreme Court and this court has recognized that there's no substitute for cross-examination of a witness.
But you can't. You're telling me right now that as the defense counsel, you could not object. You could literally not object. In other words, you could not say, no, I don't want to cross-examine that drug analyst. And that would somehow be a violation of your client's constitutional rights? You
could, but especially in this case when Verdi and Nardi were controlling, there couldn't have been a strategic decision because counsel was left to do what he could with the way that the evidence had to come in. So, in other words, this evidence...
But the evidence could have come in do you admit the evidence could have come in directly or indirectly? I mean, counsel could have said, no, I want you to call that.
Yes, I mean, counsel could have said, fine, I want you, could have agreed.
On the list of 150 witnesses or something?
I mean, just like now, counsel could agree that we don't need the drug chemist to come in to testify. Sure. But in that case, there was no choice because Verdi was controlling. So They even the examination of chemist Hagen, the chemist who testified, was these records, these notes that you're reading from chemist Lensky, kept in the ordinary course of business. They were obviously setting it up.
But they weren't admitted as business records. They weren't offered or admitted as business records, were they?
No, but he testified as if saying that they were business records. That's justifying the testimony. So, I mean, the first point is that there couldn't have been a strategic decision because, based on Verdi, there was no strategy.
Okay, so you're saying then that if he had objected to the admission of Hagen's testimony, that the judge certainly would have overruled the objection and claimed that because of Verdi it comes in?
Right. Just like
Has the court ever interpreted Verdi to include anything beyond drug testing and ballistic testing with regard to the statutory certificates?
In Nardi, this court said, when talking about medical examiner testimony, they said that test results like toxicology could still come in. And that part is quoted right in my brief. So that's why we're contending that at the time, any strategy would have been fruitless.
I'm sorry, was Nardi decided at the time of this
No,
case?
it was not. But what I was saying is that it was clarified that Verdi controlled for all business records, and it was clear that at trial that's the exception that the testimony the Commonwealth is trying to show in order to allow this to come in. Also, it wouldn't have been a strategic decision because some of the evidence that came in would have marginally helped Mr. Bizanowicz.
But you got it in. You did get that in, didn't you?
Yeah, I'm sorry.
The stuff that would have marginally helped?
It did come in, yes.
Yeah.
But if a choice had to be made between this evidence that marginally helped and evidence that went right to the center of the defense, which was that semen transferred to the decedent's shirt from the comforter when the decedent was covered when the authorities arrived at the scene, that would have explained how semen could have been present on the decedent's shirt that she was found in. The defendant argued that if his semen was present, it was because there was consensual sex at some time prior to the killing. Well, that explains why semen might be found inside the decedent, but not on the shirt that she was wearing at the time.
Okay. Is there any indication that Sandalowski was not available to testify?
No, he was not called.
So if your client had done what you say the attorney should have done to be a competent attorney, which is to object to it, and if the objection had been sustained, then Sandalowski would have presented the same evidence.
Well,
and you would not have been able to argue in closing that it should have been done in a black room. Maybe you would have been able to argue, but Sandalowski would have been able to respond to the argument that it should have been done in a black room and the test was inadequate, it was inconclusive. Sandalowski would have been there to say, no, this is the appropriate way for this test to be done, and it is both capable and conclusive.
That's true, but what we're saying based on Verdi and Nardi, the Commonwealth was doing what the rule was at the time, that this could come in under a business record exception and that there was no point in calling.
Was that discussed at any point?
Whether the exception applied?
Yeah.
No, but I mean, reading the testimony, it was obvious that that's what they were going for. They asked about how these records were kept and whether the records were reviewed, and it was obvious that that's what they were going for. And even if it wasn't discussed, we say that Verdi, and then as Nardi makes clear, that's what the exception was at the time. And not until Melendez-Diaz, which was long after this trial, was the confrontation violation recognized.
What is the cold hit?
That goes to the DNA evidence in this case.
Yeah.
In this case, we contend that there should have at least been a Daubert hearing on the DNA evidence. In this case, there was a so-called cold hit DNA match when a sample of DNA was taken from the scene and compared to the CODIS database. and a match was found.
That's what I assumed it meant. So what's wrong with that?
Well,
I mean, we just had the prior case. The defendant was arguing that you shouldn't take known people, known suspects, and use them in the array. So here we do an absolute cold thing. It's put in cold against everybody in the world or whatever, whoever is in the record. What's wrong with that?
well, I'm not saying that the cold hit is anything wrong per se.
Well, do people's DNA change over time?
No, and I'm not
So
saying
that's why we have the CODIS system.
right.
You get the hit, and then you do it leads you to a likely suspect.
Right, and I'm not saying that there was anything wrong with the cold hit. I'm saying that the ultimate statistics that were presented at trial were unreliable under the circumstances.
As I read your brief, maybe I misread
Yes,
it,
it's
but
a
it seemed to me you were criticizing the use of a cold hit, that it shouldn't have.
I'm criticizing.
Something wrong with it.
No, I'm criticizing the statistics that were ultimately used.
So
And
are you conceding then there was a DNA match?
I mean, based on the evidence presented, they presented evidence of a DNA match.
I mean, the fact of the matter is there was a cold hit during the investigation, and that's what certainly led them to your client.
Right, exactly.
But that was not the DNA evidence produced at trial.
Right.
There was nothing about that introduced at trial. They got a sample from your client by court order and then tested it against the crime scene evidence, and you had a 1 in several quadrillion chance of it being anyone else. So.
Right.
What's wrong with that?
So
That's
that's the-
basically standard stuff having
Right.
nothing to do with a cold hit.
Well, that's what happened in this case. There was the cold hit, and then there was the so-called confirmatory match, where
You call it what you want. It's a
Okay.
match, and
Okay.
it's got nothing to do with the cold
right.
hit.
But the RMP statistic was the statistics given at trial, and
Isn't that the statistic normally used?
that's the statistic normally used in a so-called probable cause match.
And that's what
situation.
this was.
No, it was a cold hit followed by a confirmatory match.
What has the cold hit got to do with the likelihood of this DNA belonging to anyone else in the world?
Well, that seems like a logical question. But the experts who have looked at the method of statistics following a so-called cold hit think differently.
Well, they don't really think differently because that's a different question. What are the chances of someone in the database being selected is a different question than we have DNA and we have crime scene DNA, DNA of an individual. What are the chances that any other individual might have this DNA?
Well,
That's the relevant question.
it's been recognized that there's a so-called ascertainment bias, which occurs when a database is searched and a match is made. And that just because there's a confirmatory match, it does not overcome this ascertainment bias.
But that would suggest that the 12 alleles, or whatever they chose, that somebody looked at the 12 alleles and said, well, I know this came from a CODIS hit, so I think they're the same when in fact they're not. But I don't think there's any evidence that there was any DNA error in terms of saying these 12 alleles match. Is there?
Well, what we're saying is that, I mean, this is an area why an expert in a Daubert hearing should have occurred.
But you have to at least explain to us why your argument makes any sense. Because
Well,
as far
I'll-
as I can see it, if 12 alleles match, then they go
Yes.
to the math as to what's the likelihood of
Right.
12 alleles matching, and it doesn't matter.
Right, and that would seem to make sense, except the experts who have looked at this, including the Natural Research Council, an authoritative source recognized by this court, have not gone with that view. Like,
Well, so how would you challenge? What would the thrust of the Daubert hearing be?
The Daubert
what would
hearing-
you try to show?
I would try to show that this RMP statistic was not accepted in the scientific community in a case where there's a cold hit followed by a confirmatory match. And I would,
What does the cold hit, I failed to see the connection between the cold hit and the confirmatory match. The jury wasn't told about it, so it's
Right.
not relevant for the jury. And just suppose there wasn't a cold hit and somehow the police got onto this guy and took his DNA and compared it to the DNA at the scene. As Justice Cordy said, that's the end of it.
right.
So
And
what does the cold hit have to do with it?
the cold hit has to do with it because that brings this so-called ascertainment bias into the case. And it's when statisticians and
So
geneticists...
everybody is biased and cheating and everything else.
Well, in order to protect from that chance, these groups that have looked at the issue have found that different statistical procedures should be used rather than the RMP following a cold hit and a confirmatory match.
What do you have to say about United States versus Jenkins, though, that 2005 District of Columbia Court of Appeals case that really took this argument you're making and completely blew it away?
Well, I think that they said that it goes to relevancy.
What are the relevant statistics?
Right.
What are the relevant statistics? That's not the subject for a Daubert hearing.
But I think...
Or what's the relevance of the statistics?
I think that they really missed the simple point. And the simple point is that these three groups, the NRC1, the NRC2, and the Balding-Donnelly group, all looked at this question. And they said, they didn't say we should use the RMP statistic. They said we should use different procedures.
So doesn't that go to the weight of the evidence as opposed to the admissibility of it?
No, I think it goes to the reliability of the evidence, because no evidence is being presented showing that this RMP statistic is reliable under the circumstances of a cold hit following a confirmatory match. And these expert groups that looked at it, I mean, I'm not an expert, and I think that's why an expert hearing needed to be held at least, because the experts are saying something different. And
Why
even
does the bias have anything to do with the RMP statistic? It seems to me that the bias would go to, if there is any bias, it would go to the selection of the alleles, the identification of the alleles by the reviewer.
Right. Again,
That's where if there's bias, that's where it occurs. Then you apply the statistics.
Well, because it's really an issue that we're contending has to be for the experts to explain. I mean, a lot of things sound logical to non-experts. But, I mean, the question in the Daubert hearing is not whether this is logical or that's logical. The question is it accepted in the scientific community? And these three groups that looked at it said something totally different. The NRC1 said, if you do this cold hit, they didn't say go do the confirmatory match and do the RMP. They said take the sample, find some additional loci, and then do the statistics based on that. The NRC2 said that still sounds good, except you could also take the match and multiply it by the number of individuals in the database, and that would give you this statistic.
It seems to me that when there's a question of bias that's involved, it goes to the question of the weight of the evidence, not its admissibility.
If there's a question, well, I think that misses the point. I mean, the point is that in order to allow scientific evidence in, there has to be a showing that it's accepted under this situation. And
well, the methodology is accepted. And I don't think there's any question that the RMP, whatever that means, the random match probability methodology, is absolutely accepted universally in the scientific community as a way to establish probability.
That's true. It's true. But in Patterson and Grinkley, both cases from this court, no, Grinkley's from the appeals court, it's recognized that just because a test or a statistic is relevant in one context doesn't mean that it's relevant in all contexts. So we're not saying the RMP is wrong in a probable cause match where the witness's DNA is compared directly with DNA found at the scene. We're saying in this situation, these three groups have looked at it. None of them have said that the RMP is the correct statistic.
But aren't those groups looking at different questions? What is the likelihood that someone will be in a certain database, as opposed to what's the likelihood that there will be a match anywhere in the world?
Well, they're looking at what statistic is proper to represent a DNA match following a cold hit, which is the situation here.
I have a question on another subject. Maybe I just am not following it, but what is the significance of the incident between Mr. Singh, the landlord, and the prior tenant, Ms. Baranowski? It's a different tenant, so what's the relevance?
Well, we contended that it was relevant as a third part to show third-party culprit evidence. Third-party culprit evidence is admissible if it's close in time and method. It may have brought a reasonable doubt of identification. And this was the tenant just prior to the decedent in an incident where police were called, where the landlord, unannounced, entered the apartment, was intoxicated and yelling at the tenant, and when police were called, he was found hiding underneath the porch of the house. And we contend that that would have been important third-party culprit evidence. Also,
To show what?
to show that the landlord was a possible suspect.
But what did he do that was anything like what was done here?
Well, just like here, someone entered the apartment unannounced.
Yeah, but
and-
wasn't there a fight going on when he entered the prior tenant's apartment? Weren't the
not-
police called to the scene because of a domestic abuse?
I don't believe so. I
No?
think they were called because he had entered the apartment.
Counsel, I'm sorry, your time is up.
Okay.
Thank you.
Thank you.
Good morning, Mr. Chief Justice, members of the court. My name is Marguerite Grant. I'm an assistant district attorney from Middlesex County, and with me is Adrienne Lynch, who was the trial prosecutor. Ms. Lynch did not try, nor did she admit the evidence of the lack of seminal fluid on the victim's living room couch as a business record. This is not how, there was no reference to business record in this case. She did not lay the foundation for that evidence as a business record, as happened in Santos. In this case, Mr. Hagan, chemist Eugene Hagan, testified that he examined the couch for fibers. He also described how a different chemist, Mr. Sandleski, had examined the couch with a polylight and found no seminal fluid. That lack of seminal fluid on the couch was exculpatory. And further, it furthered the defense theory that supposedly the adult victim and this defendant had supposedly had consensual sex some time before, and somehow that explained why there was no seminal.
Ms. Grant, the fact that one person testifies to what another person did and found, well, an officer can testify to what another person did, but can't testify to findings. I mean, that doesn't depend on Verdi or Nardi or Crawford. Police can't testify to what another police officer found.
Well, if it's unobjected to hearsay, it's in for a truth, and if it's truth, and it does depend on cases like McCowan and Greinader, where in Greinader the defense benefited from the absence of the witness.
Just as a matter of curiosity, how long is this going to keep going on? Is this just something, is this catch-up cases until we get to the cases after Nardi and the others, or are we going to continue to see cases where prosecutors are offering evidence, hearsay, this kind of hearsay evidence?
I think you're going to continue to see it because she wasn't offering this as hearsay evidence. She had 150 witnesses on her witness list, and there were jurors, prospective jurors, who came forward and said, are these all the Commonwealth's witnesses? Based on the sheer number of witnesses on that list, I don't think I can be impartial. And so defense counsel said, as outlined in the Commonwealth's brief, oh, I don't have any problem with the collection people. They're stupendous. I think we can stipulate to a lot of things. And he did enter into a lot of stipulations, and he strategically refrained from objecting to Chemist Hagan's describing what Chemist Sandleski did, because it has set up his closing argument, in which he then argued that when Lieutenant Brian O'Hara did the polylight exam on the landlord's futon next door, and O'Hara had testified, and O'Hara, very eminent, experienced state police chemist, he described all the ways that he examined the futon, but because the jury didn't hear Sandleski, that set up defense counsel in closing to be able to say, well, we didn't hear if he turned out the lights.
Well, it may be helpful in the future if something like these agreements, whether they go beyond written stipulations, if these agreements are put on the record somewhere so that we don't end up in these kinds of disputes.
But there was no agreement. There was just defense counsel strategically not objecting, waiting, setting up what he thought was a brilliant strategy for closing. And so what you're saying is the prosecutor would have to at every interval go to sidebar and say, okay, there's no objection here, there's no objection here.
Well, when you offer evidence which is plainly hearsay, which doesn't happen that often, especially with regard to scientific results, it's not crazy to go to sidebar and say, I realize this is hearsay, and you realize there could be a 33 issue, and there is a strategic reason why the defense chooses not to object. I mean, that's not
And
crazy.
that had happened during motions in limine on many occasions, during jury selection on all the occasions when defense counsel said, I'm not objecting to the collection people. I think the collection people are stupendous.
Yeah, by the way, was it stupendous or was it superfluous and an error of transcription? I wondered about that.
Oh, I don't think it's stupendous. Because he repeatedly said
It's not the right word, though. That means he's saying that the collection people
are wonderful. They did a
right,
wonderful
are
job.
wonderful. So then why is he saying he doesn't want them? That has no relevance to why he doesn't want them.
He's saying he thinks they did a wonderful job, but there wasn't enough testing done on what they collected. And so he doesn't want to undermine. He does not want to stand up in a forensic case and have Ms. Lynch have yet more experts on direct examination. He would rather have her refrain from calling an expert and then be able to argue in closing that the absence of that expert somehow helps the defendant. But there was no seminal fluid on the couch.
Well, you're analogizing this maybe to when somebody is successful in keeping out testimony, then can't argue that the testimony didn't come in.
Correct, which was McCowan.
Yeah.
And yes. As far as the DNA evidence issue, as the court noted, this was not a reliability question. It was a relevance issue. And the court has citations to U.S. v. Jenkins and also the Superior Court judges' findings and rulings in Commonwealth v. Guy. And but in addition to that point, I'd point out that the hit here was not cold. The police had already spoken to this defendant prior to them testing his DNA. And it was at that point when, after the landlord's DNA turned up negative, that then there was a test done on the defendant's DNA came up as a hit in the CODIS database, and so the attention was already drawn to the defendant. This was not a cold hit.
But is there any evidence that the person who did the company that did the analysis of the sample of the defendant's DNA that was ordered by the court and compared it to the sample that was taken at the crime scene knew that there had been a prior cold hit? Is there any evidence of that?
I don't remember. It was Kristen Sullivan was the witness, and I don't remember whether that was. It certainly wasn't elicited during trial.
So it's not in the record.
Correct.
So how, we don't even know if there's any bias.
Correct. And in fact, defense counsel filed a motion in limine to keep out evidence of the CODIS hit, which is at page 306 of the supplemental record appendix, and also.
Yeah, but the relevant point, it seems to me, based on what he's arguing, is that the analyst who's doing the test for forensic purposes to be presented at trial not know that there had been a prior CODIS hit. There's no need for that person to know it, is there?
No, but that argument wasn't made below. It was this kind of smoke and mirrors argument about the math that was made below. And so Judge Laureate ruled pre-trial, relying on the Commonwealth v. Guy, Commonwealth v. Maxwell, and U.S. v. Jenkins, that those are different questions. But I'd also point out that what Judge Laureate had before him was this unsworn declaration of this UC Irvine professor. And based on cases including Commonwealth v. Bly and Commonwealth v. Schumann, which Judge Laureate cited, under Rule 13a2, he could have denied the motion for that reason alone. It's not enough to get an evidentiary hearing or a Lanigan hearing just to have somebody say, not even under oath, I think there's a dispute.
But I gather that even with regard to that, whatever that letter, the letter didn't say that there's going to be that the determination of whether the alleles match is subjective, and if the DNA person doing that knows of a previous CODIS hit, that will be affected by their knowledge. I guess that was not the argument below.
No, it was a math.
Okay, so that was never, the judge was never told you need this hearing to evaluate this risk of subjective bias in the matching of the alleles.
Correct. As far as the information about the landlord, that was hearsay. The defense was trying to get in through the testimony on cross-examination of State Police Detective Lieutenant James Conley to get him to say that Doreen Galante had told police that the adult victim had said that she supposedly had a relationship with the landlord. Now, what did come in at trial was all kinds of information about what the police did to investigate the landlord. They went into his house, they tested his futon, they examined the liquor bottles and glasses for fingerprints. They found none.
What were the circumstances of the landlord going into the prior tenant's apartment? Was there a domestic dispute that was going on?
What the record shows is that the landlord's wife testified that the tenant was noisy. She was having a fight with her boyfriend, and that the landlord went to her deck or to her back door.
In the course of this dispute?
Correct.
Yeah.
It's not clear from this record whether at what point the police were called or who called the police. The prosecutor, during the cross-examination of the landlord, the prosecutor said, I have witnesses from the Woburn Housing Authority that will basically say this is a problem tenant. And if defense counsel wants to go there, I have them here to testify. The judge precluded defense counsel from cross-examining the landlord about the incident, though he had cross-examined the wife about the incident. And though the landlord did testify that the prior tenant was noisy.
Was this a 2 or 3 family house with an owner occupied?
Yes.
The landlord was lived there in the same house?
Yes. It was a side-by-side duplex, 2-family. And the landlord admitted he was in the victim's apartment on many occasions. And so this information about the landlord, first of all, what the police did to investigate came in. The information is not admissible for its truth to prove any third-party culprit because it's not close enough in pattern to what happened to the victims in this case. It's not like a scenario like Conkey, where there were quite alarming prior incidents. The idea of a landlord going into an apartment or with a key is not something that's so unusual that it would immediately give rise to, a pattern. And furthermore, as far as McCowan, the jury heard plenty of evidence about what the police did to investigate, and because of the fact that the defense counsel was trying to have his cake and eat it too. He was trying to claim he didn't want this information in for its truth, but yet he was trying to use it to build some sort of an inference based on nothing, just insinuation and hearsay that there was some relationship between this victim and the landlord. And that's exactly like in McCowan, where the court said, well, he did want this in for its truth. And it doesn't come in for its truth. In addition, I would point out that cases like Ridge and Silva Santiago are distinguishable because there was no rape shield issue involved there. Here, the rape shield statute precludes this information from coming in unless it comes in to show some sort of physical condition of the victim. Unless the court has any...
Just to be clear, was there ever a rape shield motion made by the defendant?
No. And in fact, there was a rape shield, a motion eliminated by the prosecutor to preclude evidence based on rape shield. And on several occasions, I think it's 3 or 4 occasions, the judge said during pretrial hearings and during early objections or during the case at sidebar, I haven't seen any rape shield motion. I haven't seen any rape shield motion. And at that point, defense counsel at one point said, well, I'm not admitting for its truth, and I'm not going to say that there was actually any sex between them, so therefore rape shield doesn't apply. But then he's trying to say that something happened in the basement that amounted to a motive for the landlord to commit murder, when there were no fingerprints on the glasses, there was no seminal fluid on the couch, the landlord's DNA did not match the DNA found in and on the victims. This jury found the defendant guilty of the first-degree murder of Alyssa Presti on all theories of first-degree murder. It found the defendant guilty of first-degree murder of Joanne Presti as both felony murder in the course of an aggravated rape and by extreme atrocity or cruelty. What the jury didn't know is that, but the record does reveal, is that this defendant was at the time on probation for child rape, 5 convictions of child rape out of Essex County, and he was a level 3 sex offender.
Okay, but what is the relevance of that on appeal?
That there are cases that say that the court may consider evidence not known to the jury in the course of its 33E review, and I refer to Commonwealth v. Coyne in 420 Mass.
But you're not suggesting that if there was to be a due process defect, it would be overcome by his prior record, are you?
No, but my understanding is that in the course of 33E review, the court can consider the whole case and can consider more abstract concepts such as clemency, and in that consideration, I call that to the court's attention that this is not a defendant who is deserving of clemency by this court.
And do we have in the record his prior record?
There is reference in the defendant's motion in limine to exclude the prior record to some detail of what that prior record contains. There is also reference, it's cited in my 33E argument, at sentencing to the prior record.
But if you're right, a DA in every murder case should be providing us or should be putting into the record the prior record in order for that argument to be presented, but they never do. And are you saying they should?
Commonwealth
You didn't,
well,
except through that.
it's in the record, and that's part of the reason I have in the past Commonwealth v. Whitaker White in probably about 420s, 423, I think. I have moved to do that in circumstances when defense counsel has asked for clemency based on the purported lack of record. But in this case, part of the reason in my 33E argument I cited to defense counsel's motion in limine was to make sure that there would be no dispute as to what that record is. There's also discussion. It's part of the reason why we have sentencing hearings on first-degree murder cases, even though there's a minimum mandatory sentence involved. The defense counsel and the prosecutor discussed his prior record with the judge at sentencing, in addition to in the motion in limine, and in the court's consideration of whether this defendant deserves clemency, I would suggest that that is further evidence that he does not. Unless the court has any other questions, I will rest on my brief.
Thank you, Counsel.